Good morning. My name is Dan Dodds. I'm the principal attorney at the Dodds Law Firm in Surprise, Arizona. And this morning I'd like to talk to you about an area of family law that is quite frequently of interest to most people, and that is, how will the court divide the property, the assets that we've amassed during the marriage, and the liabilities we've incurred during the marriage? Excellent question. And there's many variables, so I'm just going to try and show you the principal foundation of this, and then you have to apply the facts to determine whether things like transmutations have occurred or not. But generally speaking, the foundation is this. There's two kinds of property in most marriages. Separate property, the property that they owned individually before they married, comes in to the marriage as separate property, and unless there's been a transmutation, it comes out as separate property for both spouses. The presumption in Arizona is that any assets of any nature that were acquired during the marriage, regardless of the source of money, is going to be community property. And that would be divided equitably. It's not on, the wife put 10% down and I put 40% down, therefore I should get more than she gets. That's not the way the court looks at it. They would look at it as you both put some money in it, but it was a community property asset, therefore it's going to be divided equitably. So there's another area of separate property, and that would be gifts. Wedding rings are a good example. You gave that to your husband. You gave that to your wife. And it's hers or it's his. They don't divide the ring set and say, well, you get the engagement ring and you get the wedding band. They don't do that. Any gift you got at Christmas, perhaps, or birthday, is your sole and separate property and would be treated as such. The issue of inheritances. In other words, one of my relatives passes away and in their will, they provide that I get $10,000. Well, as long as I don't commingle that money in a joint account, let's say I buy a $10,000 CD and it's only in my name, well, then it's going to stay separate property. If you had a separate bank account that was only in your name and you put that money in there and you don't commingle it, that's pretty likely going to be considered to be separate property and it would come back out. But the presumption again is that community property is everything that was purchased or acquired for the benefit of the marital community is going to be divided equitably. You can't argue that, well, I bought myself a new hunting rifle, therefore, and I paid for it with my money, therefore it's my rifle. No, that would be divided between the two. So you're going to have to either exchange some cash or trade some asset to offset the value. I could keep the rifle, but she may be able to keep all the pans and dishes and the things that would be of equal value. Liabilities, in other words, what do we owe together? That's divided equitably. And I think a good way to look at it is that, people would say, well, okay, I'll keep the Home Depot card and the Lowe's card, and you keep the Victoria's Secret and the JCPenney's and the Macy account. And as long as it's somewhat equitable, the court won't care. I think in passing, one of the things I would say to you that typically the worst way to do this is to not find a way to agree on all of it or most of it and go have a judge do it for you. Because many times they'll go, well, you know what? I don't know what that furniture's worth, so let's find out. We'll sell it and divide the money. Courts can divide money really easily, but they can't say, well, that lamp is worth more than this table. So I always encourage my clients to sit down and have an honest discussion about what I should be able to keep, what you should be able to keep, and that if there's something that we can't agree on, well, then let's decide what we're going to do with it. We're either going to sell it, give it away, donate it to church, do something with it. Otherwise, that's exactly what a court will do. They will order you to sell it and that the proceeds be distributed. The last thing I want to speak to is what happens if during the marriage I go and buy 20 acres in Oregon, and then the divorce comes. What about, and I only had it titled in my name, not my wife's name. Arizona will treat it, regardless of how it's titled, if it's out of state and was purchased during the marriage, they're going to treat it as a community property asset. So you kind of want to think about that. If you're married and you're not divorced at this point, but you're watching this video, you want to remember that if you divorce in Arizona and that property was purchased during the marriage, the presumption is it's community property and the court will divide it equitably again. I hope this helps you understand how assets and liabilities are typically divided by the statute. Again, I would urge you to, and your spouse to think carefully about that before you make a decision.